Alrighty. Hello, everyone. My name is Sarah Housley, and welcome to the Scottsdale Public Library's virtual program, Essential Estate Planning, presented by Scott Sandell. Scott is the president of the Phoenix chapter of the nonprofit organization Foundation for Personal Financial Education. Without further ado, please welcome Scott.
Hello, everybody. I'm glad we have a nice sized group today. I'm going to try to keep everybody on mute just to limit the background noise. If you have a burning question on a slide that I am on, feel free to unmute yourself and chime in and then remute yourself. That way we can keep the flow going. Otherwise, the chat function works well as well. I'm multitasking on several screens here, so hopefully I can keep up with questions on the chat function as well. I also open things up at the end for questions. And we also have a public open format question and answer via Zoom on April 12th at 5 p.m. So it's a Monday at 5 p.m. on estate planning as well. So plenty of opportunities to ask questions. If you want a copy of these slides, you'll notice contact information at the bottom of most slides, except these first couple of slides. And you're more than happy to shoot us an email or give us a call and ask us for a copy of the slides, and we'll send them over to you. Never have a problem sharing the slides. So let us know on that side as well. All right, so let's get started. For those of you that are new to us, I have been running the nonprofit Arizona chapter of the Foundation for Personal Financial Education for about 7 years now. I have a master's degree from University of Arizona focused in finance. CFP classes are all done at Pepperdine University, and then I own a local family of companies that includes a wealth management firm and a tax firm. I purposely don't have an attorney doing this presentation because unfortunately, being in this business as long as I am, I'm pretty cynical, and most of these educational classes or seminars that get put on by attorneys are trying to sell you trusts. So I worked with attorneys we trust to create some good education on wills and trusts, and this is what we came up with. So hopefully you'll be able to decide from an unbiased standpoint what it is that you need and what is entailed in that. With this class, which is really the meaning or the essence of this class is it's the will versus the trust, and who needs what and what's entailed and what you have to worry about. So legal disclaimer before we begin, this is for educational purposes only. Please understand, anybody in the financial, legal, tax world speaking to a group of people, it's never direct financial advice or legal advice. This is for educational purposes only. Everybody's in a different situation. So we are talking in general. We are not talking specifically about your situation. All right. So let's kind of go through what we'll talk about. We're going to start with some basic knowledge that we all need to have. And then we're going to split off and talk about a will-based plan versus a trust-based plan. So you'll get good base knowledge of what's entailed in both sides of that. And we'll talk a little bit about large estate considerations and bring it all together at the end there. All right. So the basics. What is estate planning? Well, the first thing we need to understand that is estate planning is maintaining control during incapacity. So while you're alive and well, you're in control of all your stuff. But if you start becoming incapacitated, whether it's dementia or Alzheimer's or an accident that puts you in the hospital and you're on drugs that won't allow you to make decisions, you know, there's many different scenarios that includes. Then documentation will help guide things as your wishes are iterated on the documentation. And then quick and cost-effective wealth transfer upon death. This is really an important part about this. A lot of people, I find nowadays, a lot of people don't really care how much they leave their heirs. It's just that they don't want to leave a burden. I've only met one person that purposely wanted to make things a mess to leave their heirs a burden. And that was a very interesting conversation. But for the most part, we want to make it easy on our heirs, and we'll talk about what makes things easier for your heirs, because this is the part that really gets made difficult on purpose by people in this industry. And then protecting beneficiaries from themselves and others. Sometimes you have difficult beneficiaries. Sometimes there are arguments, and how those get settled and things like that can be handled in the estate planning process. So that's really the world of estate planning in a nutshell right there. The next part of this is, what is your estate? And I have to remind people, it's everything. It's the cars, it's the houses, it's the investments, it's the jewelry. If Antiques Roadshow goes through your house and finds $1 million desk, then that's part of your estate. So we do have to think about that in some cases. There are family heirlooms that could be worth quite a bit of money, and that's where sometimes things get a little messy later in life. So we can't just look at the investments and the bank accounts. We have to make sure we keep an eye on everything. All right. Then documentation and when it's good. So when you go with a trust, if you choose to have a trust, the effectiveness date of that trust is the day you create it. It is a living document. It's kind of like creating your own company and naming yourself as the CEO or the person that's in charge of everything and makes every decision. Well, that's really what you're doing when you create a trust, okay? Now, when you become mentally incapacitated, that's when the powers of attorney will come in, okay? If there is a catastrophic illness that forces you on breathing tubes and feeding tubes and all those types of things, then the living will comes in, okay? That's different than your last will and testament. Your living will says pull the plug or don't pull the plug, feed me, don't feed me. What does your end of life care look like? And that's been a point of contestation these days with COVID. You know, people in their living will say, I don't want to be on a breathing machine. But in order to combat COVID, some people end up on these ventilators, and it's against their wishes, but it kind of is not necessarily an end of life treatment. It's in that case, trying to get you past COVID. And so there's definitely some gray area in the living will that we've learned that we have to deal with. So this is really instructions on end of care treatment. And then once you pass away, I want you to understand the power of attorney, they're done. They're worthless. Once you pass away, there is no such thing as a power of attorney. Okay. After that, it's whoever you name to be in charge of your trust or your will that will execute your wishes. Okay. And they don't need a power of attorney at that point. All right. So the question really is when should you get documentation? When should you do your will-based plan or your trust-based plan? And that answer is simple, but very gray. It's before anybody can say you were mentally incapacitated. So for some of us, that's arguable, and for some of us, it's not. And so we have to understand that a big point of contact, a big point that heirs might cause issue with are changes or the creation of documents after they deemed you mentally incapacitated. You might have felt fine, but they may have been questioning your mental incapacity. And that's important to understand, that we want to try to set up this documentation when nobody's going to argue that we were mentally incapacitated, and then we don't want to touch it after that. Okay, you might have to update a power of attorney here and there, but changing beneficiaries and things like that. After my mother-in-law was diagnosed with Alzheimer's, we basically just gave her a notebook and said, hey, this is your trust. Anytime you want to change something, go for it. Because she woke up every day and wanted to disinherit somebody and give it all to this person and give it all to that person. And it literally changed every day. So we do have to be careful about the changes we choose to make when somebody can argue we were mentally incapacitated. All right. So What is everybody afraid of? Well, the word probate tends to be what drives this whole conversation of whether you want a will-based plan or you want a trust-based plan. And this is where we see a lot of the skewing of the truth in these sales seminars. This is what we have to be careful of. Probate is not that scary. Trust me, we've seen lots of them in the years that we've been in this business. And the reality is with a valid will, I saw one done here in Arizona not too long ago that took all of 2 weeks. Okay. The reality is a trust or a will guide the process through probate. And that's right. Even if you have a trust, you may end up in probate. And that's a huge misnomer about this whole conversation. Just as likely to end up in probate with a will as you are a trust. And a lot of people don't understand that. And we're going to get to the root of that problem. It's very simple. Okay. The problem comes is when you have no documentation at all. If you don't have a will or a trust, that's when the nightmares begin. Okay, when you already have a difficult situation, Prince, think about Prince and how difficult his situation is with businesses and record rights and all this stuff he had going on, and he had no will, no trust, no nothing apparently. Well, that's a disaster. You know, if you die and have a small bank account in the house, the probate's not going to be that difficult, especially if you only have 1 or 2 kids. They're just going to split everything evenly. But it will go through a process. And that process, when you don't have a will or a trust, is really a long drawn out process. Each court where property is held will appoint a personal representative. Meaning, if you have a house here and a house in Minnesota, you're going to have 2 courts working on this. You'll have 2 representatives working on this. That's 2 people that want to get paid too. Okay, so they have to locate and go through, notify the public the estate is being probated, locate and value all the property, pay any debt and expenses that you left over, and then they have to pick and choose who and what they're giving everything to. Okay, so the courts are in charge of all of this. That process really is arduous because every time one of these representatives that are state appointed wants to do something, they got to go into the court and get permission. And every time you do this, there's court filing fees, there's a whole bunch of time that goes by. And that's why this can take years to handle, because these are people that don't know anything about you. And they have to start from scratch. They have to be detectives trying to figure everything out. And that's why this process is just kind of so painful if you leave this world with no documentation. So that's what we have to avoid. Okay. A lot of weird scenarios out there. I mean, Marilyn Monroe, her estate took 18 years to settle, and the heirs only got $101,000 after everything was said and done. Elvis lost 73% of his estate to fees. And then the Prince debacle that's going on right now, and who knows how long that's going to last. All right, so hopefully that convinces you that you need at least a will or a trust. No matter what, you need one of the 2. And I don't care what phase of life you're in. You could be 18 years old and theoretically you need a will-based plan or a trust-based plan. It doesn't matter what phase of life you're in. You need these things. Okay. So let's talk about these. The first one we're going to go through is going to take care of most of you, which is the will-based plan. And then we're going to contrast the difference with a trust-based plan and show you the type of people that really do need trusts. Okay. So let's start with the will-based plan. Hopefully, there it goes. Okay. So this is really, how do we efficiently get our assets to our heirs? This is no middleman here. When we put a trust in there, there's a middleman, which is the trust. The assets go to the trust then sends it all to the beneficiaries. So when we look at a will-based plan, we have to understand the legal side of how property transfers, property, assets, money, anything you own. We have to figure out how it transfers legally. Okay, we have a very strict set of rules on what takes precedence over another. Okay, So this is by far the most important part of this entire class, okay? It's understanding legally what comes first, second, third, fourth, and fifth in terms of priorities on transferring wealth. Priority number one is ownership documentation, okay? Think about the title to your house or your car, okay? It lists who owns it. Your bank accounts list who own the bank accounts, okay? So if you own your house jointly or your car jointly or your bank account jointly and one of you passes away, the other one still owns it and is alive and retains all rights. It doesn't have to go through any process. It's already taken care of. Show them the death certificate, they'll take their name off of there. That's it. So priority number one is ownership documentation. That trumps everything. Okay. Avoids probate if an owner is still alive. Okay. Next, beneficiaries are priority number two. This is the most important thing to understand about this priority totem pole here. You can list beneficiaries on any monetary account. Your bank accounts will take TOD, transfer on death. Your IRAs, 401ks, 403bs, you can put beneficiaries on those. Your Roth accounts, you can put beneficiaries on. Your annuities, your life insurance, any monetary value account will allow you to put a form of a beneficiary on it. But what a lot of people don't know is here in Arizona, you can put a beneficiary on your house. We have a deed called a beneficiary deed. It's the same as the deed you have on your house now, except it lists a beneficiary should you pass. If both owners or the owner is gone, then it already lists who inherits the house. Also, our motor vehicle department allows you to put a beneficiary on your car. So let's think about that. If you put a beneficiary on all your money, beneficiary on your house, and a beneficiary on your car, and that avoids probate. That's the key. That avoids probate. What do you have left? Typically, we just have the stuff in our house. We have the silverware in our drawers, the pencils, the clothing, the jewelry, that type of stuff. We just have stuff. Well, none of that has titles. Nobody's holding the beneficiary paperwork. That just needs to get handed out. And that's where states will say anything less than $90,000 doesn't need to go to probate. Well, if your stuff is less than that $90,000 range, then your will just dictate who gets what. So whoever you assign to be in charge of your will go into your house, have a big garage sale, sell everything and split it up amongst the kids based on that's what your will said. And if you had some jewelry you want your daughter to get and the grandfather clock you want your niece to get, you can list that in your will. Okay. But there's still no probate needed. Okay. This is just your personal stuff and you saying what you want to do with it. Okay, so ownership documents need to be properly put together. If you are married, all your bank accounts should be joint. Your investment accounts, other than your IRA and your Roth accounts, they can all be joint except those two. Okay, make them all joint. Jointly own your house, jointly own your cars, and then everything else should have beneficiaries. Okay. When I say everything else, everything that you can put a beneficiary on should have your beneficiaries. So your IRAs and your Roth accounts should have your spouse as the primary beneficiary and your heirs as the contingent secondary beneficiaries. So now you've taken care of what happens if you pass away, but also what happens if both of you pass away if you're married. And then single is just easier. Bypass anything that had to do with a spouse there. Okay. So when we talk about a simple way to hand things over to your heirs, if you do this properly, there is no probate. People get a very strange understanding about this whole process and think that if you don't have a trust, you have to go through probate. Well, that's only if you don't do the proper titling and beneficiaries. And I got news for you. If you don't do that stuff right in a trust-based plan, you're going to probate. Okay. And that's the biggest problem with all of this. I meet people all the time and they come in and say, well, here's what we've done and here's what we got. And I can look through it, and inevitably people that have trusts have never properly funded the trust, as we call it. Meaning they haven't sent their money to the trust. They haven't taken care of the titling and the beneficiary designations on everything and pointed it to the trust. And inevitably we find things that are going to cause probate. And that's the biggest problem that we see out there. If you have a bank account that's just in your name and has no beneficiaries listed on it, let's say Chase has it. If you pass away, no matter how much money's in there, Chase doesn't know who to give it to and who they're supposed to trust. The only thing they'll take is a court saying, yes, this person should get this money. So that money will just sit there at Chase until somebody legally tells them where they're supposed to send it. And that's the problem we get into, is you have to do this properly, whether you're choosing a will-based plan or a trust-based plan. And if we're trying to keep things as simple as possible, this is as simple as it gets. And when we talk about ironclad, well, if Wells Fargo has your bank accounts and Schwab has your investment accounts, and you list your beneficiaries on there, well, Wells Fargo and Schwab are going to make sure those beneficiaries get exactly what you listed on the documentation. They don't care who's arguing. They have their instructions. They can argue all they want. The only way these companies will send the money out is the way you instructed. They could care less whether somebody else is arguing. You know how big those entities are. They don't care. They have layers of customer service to deal with things like this. Okay, so make sure we understand that listing these beneficiaries is pretty close to as ironclad as you're going to get when you do it properly. Okay, so a couple of quick questions that popped up here. Can you name contingent beneficiaries on the real estate? I don't believe our Arizona beneficiary deed allows anything other than a primary beneficiary. But I'm not 100% positive on that one. You might be able to get super fancy and put a contingent beneficiary, meaning if something happened to your primary beneficiary, can you list a backup? I'm not sure you can do that. I know you can't on the cars, but I'm pretty darn sure that you can't on real estate. Then next question, can you name charitable organizations as beneficiaries? Absolutely. With a little bit of difficulty, just so you know. You certainly can name them as beneficiaries, but then somebody's got to be there to get the money to those beneficiaries. So there's got to be some type of person in charge that knows that your account had that beneficiary, and that beneficiary needs to go claim the money, because Chase will send out, you know, or Wells Fargo or whatever entity holds your money, they'll send out, hey, so-and-so charity, this person left you as a beneficiary. Well, that documentation might get thrown out as junk mail. That gets missed occasionally. So it helps to have somebody in charge that knows you wanted money to go to that charity, because these entities won't just randomly talk to anybody except the beneficiaries. So they'll tell you, yes, you're a beneficiary, or no, we can't talk to you. So that's just the little hitch on that. Okay. And then looks like, I'm not sure what this question means, but so LLCs are out. That opens a whole world of, I'm not sure exactly what you're getting at. LLCs certainly can, you can have the trust own an LLC. It depends on what formats you're really looking at. If you are self-employed and own a business, then certainly that's going to be someone who needs a trust. The more difficult situations, mixing in businesses, as you will see, will definitely need trusts. Okay, so this is again a will-based plan. We still have one more on this totem pole, which is a big exclamation point for those of you to be careful. Gifting. Notice what it says here. Can be overwritten by all of the above. And quite often we see late life gifting. Okay, we have to be very careful about this late life gifting. We have to understand that if you were downsizing and getting ready to go into long-term care, and your niece was helping you, and you decided to give the niece the grandfather clock because she said it looked so nice, but you forgot in your will that it says it goes to your son. And after you pass away, your son looks at that and says, well, I'm supposed to get the grandfather clock. Well, the son has full rights to take the grandfather clock away from the niece. Okay. The gray area that starts happening is when you start gifting money late in life. Okay. Maybe you have a great grandchild or a grandchild going to college and you want to start giving them money. But then your beneficiaries and your gift, your will says everything's to be split at 50-50 to son and daughter. But the daughter had 3 kids that you helped through college and the son didn't. And all of a sudden they start arguing that the son should get more because you gave all these grandkids all this money and the son didn't get anything. Okay. Now, is it right for them to argue? No, we don't like seeing things like this, but that's why they happen after you're gone. So try to understand that when you look at late life gifting, we have to look at it to be as fairly as possible and as open as possible. If you're going behind somebody's back and gifting, we got to make sure everybody understands. Okay, so be careful about this stuff because they cause problems later in life. All right, question came in. You can get beneficiary deed form from Secretary of the State, and I believe it does give the options for contingent beneficiaries. Look at the form. Okay, thank you, Michelle. She says that the Secretary of the State has the beneficiary deeds available, which in Maricopa County have been hard to find. So that's good. I'll look for those. I've done beneficiary deeds. It's just I have title companies do them. I didn't know they had the contingent beneficiaries available. All right, so let's move on. This is the way property transfers, and this is an eye opener for a lot of people. And this is the absolute essence of a will-based plan. We have to do the titling, the ownership paperwork properly, and the beneficiaries properly. Okay. The next side of this, the documents that you need. It's fairly simple. Last will and testament. Okay, really all you're doing in this, because keep in mind, your car, your house, all your money has already transferred and has nothing to do with this. Okay, this is a backup if you end up in probate. Okay, the purpose of this specifically is to nominate a personal representative. If you die and nobody's in charge, then everything's going to sit around and do nothing. Okay, so there should be somebody that has this documentation and knows what to do with it. State what personal property goes to whom. Again, if you have family heirlooms or things you want to go to specific people, then you can list it out here. And then nominate a guardian for minor children. Okay, not typically a problem when people die of old age, really. I mean, we don't typically have minor children, but younger people should have documentation too. And people that, with families and all that stuff, we need to have these things. So if anything tragic happens and you have minor children, we need to know who's supposed to be in charge of them. Then the living will. Okay, living will says pull the plug or don't pull the plug. This is the end of life care. This is going to tell your medical power of attorney to do what you wish. Okay. So medical power of attorney will use this document to guide their decision making when you are on life-sustaining treatments. Then there's the medical power of attorneys. In Arizona, we have 2. Okay, mental health care power of attorney and medical health care power of attorney. These are 2. Some attorneys will pull these together in one long power of attorney. But our state attorney general has these available and are 2 separate documents. And I'll tell you about where to get all this stuff in a minute here. So 2 medical power of attorneys. And then the last one is a financial power of attorney. Okay, and this can be springing or good at any time. So understand, springing says there's a list of things that have to happen for you to now have power. Okay, 2 letters from doctors saying I'm mentally incapacitated. For instance, my mother-in-law, we had 2 separate diagnoses for Alzheimer's before we took over the finances. My mother-in-law at the time still didn't believe there was anything wrong with her. That's part of the problem of aging, and whether it's something as defined as Alzheimer's or just dementia, or some people just call it sundowners, we don't really know anything's wrong with us, and that's a slow progression that we have to be very careful of. And so that's where the springing versus good at any time. If you truly trust your kids and they're going to be in charge, or whoever this is that's going to be in charge, you can just say it's good at any time that you decide to need it. Okay. Scares a lot of people to do that. Okay. So keys to a will-based plan. So the first part to understand is this is for simple estates. Single state real estate ownership. So the problem with this is when you own real estate in other states, not all states allow beneficiary deeds. And some states will say, hey, wait a second, we want to claim this as their primary residence and have control over everything. And so you end up having issues, especially if you end up in any form of probate. So typically, if you're going to own real estate in multiple states, you got to look into the specifics of that state. If they allow a beneficiary deed, maybe it's just a rental home or a second home or a cabin or something like that, and you just want to put a beneficiary deed and keep it simple, that's perfectly fine. But there are many states out there that are much more difficult than Arizona. California is a great example. You can't own real estate in California without having a trust. It can be very messy over there. So be very careful. It has to be single state real estate ownership. If you have multiple state, then you have to take an extra step to kind of look into the rules of that state. No business ownership. If you own a business, it's probably time to start looking at a trust, and that addresses the LLC question. If we're getting fancy and owning a bunch of LLCs, then it's probably time to start a trust. Okay. Simple family dynamics, we've seen a lot. Whether it's you want to disown one kid and give 80% to another kid and 20% to one kid. Okay, this starts causing problems, and the more difficult the family dynamics, the more you want to typically start looking at trusts. Children with special needs. Great example of definitely needing a trust. There's a trust that's literally built for that situation called a special needs trust. So if you want to remain in control after you pass away, if you want to control this money and how your heirs use it, you move to a trust. Okay. If you just want to split it up, send it off and move on, then that's possible with a will-based plan, or easier with a will-based plan. And then there's the less than the lifetime estate tax exemption, which is pretty easy for most of us because individually it's over $11 million currently. Okay, it will go back to about 5.5 million plus inflation in 2025. And yes, there are people talking about lowering these limits. But it would have to take everybody signing off on it and enacting a new law. So it's a lot more difficult than it used to be. It used to just be a yearly negotiation. Now they actually have to enact a law to change it, because we made it permanent at 5 million plus inflation, and then we temporarily doubled it to 2025. So the dynamics of changing the lifetime exemption is a little more difficult than it ever has been in the past at this point, not to say it won't change in the future. And we'll talk about larger estates a little later, so more specifics on that coming up. So in a lot of cases, the amount of money doesn't say you need a trust. If you have $5 million, that doesn't mean you need a trust. Just because you have 5 million doesn't say trust or will-based plan. If you had $20 million, I'm going to tell you, you absolutely need a trust. Okay. But if you're under the lifetime exemption, the trust is not specifically needed because of that. Okay, so if you're doing a will-based plan, proper titling, primary importance, very important. Only second to beneficiaries, because every account will have a beneficiary. After you have the ownership taken care of, then the beneficiaries need to be taken care of. Okay, so proper beneficiaries is really important. When I say proper beneficiaries, let's think about it like this. This is a big mistake I see quite often. Beneficiary forms filled out by somebody that doesn't know what they're doing happens 90% of the time. And that includes you filling out your own. You're not lawyers, you're not estate planners, you're not even financial advisors. So the reality is you have limited knowledge in beneficiary forms and how they work. And so the one scenario that we always want to bring up is let's say you have two kids and they each have grandkids, and these are the kind of grandkids that you like. Not all of us like our grandkids, but yeah, you know, these ones you like. So you have kids and you have grandkids. On your beneficiary forms, you just list your son and your daughter. Okay, 50-50. So each beneficiary form says son 50%, daughter 50%. Let's say you pass away on a plane with your son. Okay, so you're gone and your son's gone. Or even worse, your son passes away and then you pass away 2 days later. Whatever the case may be, tragedy happens, your son's gone and you are gone. The question that I have is, where does your money go? Your daughter is listed as a 50% beneficiary. Your son was listed as a 50% beneficiary, but your son is no longer alive. So where does his 50% go? And that's where filling out these forms properly comes in, okay? Because if you just listed their names, 50%, then the daughter will get 100% and you disinherited your son's family. You disinherited the grandchildren, okay? But some forms let you put per capita or lineal descendants per stirpes. If they don't, you can write it in. You could put son lineal descendants per stirpes, daughter lineal descendants per stirpes. And what that means is if son's gone, then your grandchildren, it'll stay in the bloodline and the grandchildren will split that inheritance and stay on this side of the family. Okay, per capita means, let's say there's two grandchildren over here, then the three heirs now will split it up 33% each. That's per capita. Okay, so now you reduced what your daughter was going to get because two grandchildren, or God forbid, I just met a family with 13 kids, I think, 13 grandkids and one daughter, 13 grandkids would dilute the pool drastically if you put per capita on there. Okay. So there are things you can do on these beneficiary forms to mitigate difficult circumstances. We had it come up the other day where we needed a big life insurance policy that was forced by a divorce, and the beneficiary was supposed to be the son, the minor child. Well, obviously the minor child was, you know, if they inherited or received from the death benefit millions of dollars, somebody would have to be in charge in that. And they didn't want to put a trust together. They just had a thing. They didn't want to put a trust together just for this, you know, this divorce decree thing that they had to do. So on the beneficiary form, you can actually list who's in charge of the money until the son became of age. And so there's a lot of things you can handle on beneficiary forms when done properly. And so just listing names, you got to be careful about that. Okay. The other weird thing is consider life insurance annuities and reverse mortgages to protect assets. That looks really strange to most people. And some people go cross-eyed. Some people just flat out get angry when I say things like this. I only bring this up for some interesting little tidbits that come out of this. You know, if you have an IRA at Schwab and you're invested in the stock market and everything's going wonderful and you pass away, but you have $1 million in medical bills when you pass away. Well, all that money has to pay the estate's bills before it goes to your heirs. And that's where the difficult issue becomes something to think about, okay? Because life insurance and annuities, these two products in particular, are creditor and lawsuit protected, meaning they go to your beneficiaries and are not obligated to pay any of your bills that you've left over, okay? And then the other thing is, on kind of the opposite side of the spectrum, reverse mortgages. If you own your house free and clear, many attorneys get reverse mortgages when they go to retire and they don't use them. They leave them empty. They're a line of credit that they have available to them. And there's a very distinct reason why, because that takes first position on your title. And now your HOA can't get an argument with you and kick you out. If somebody sues you and puts a lien on your property, it's on after the reverse mortgage. And here's the big one: Medicaid, Arizona Alltech. Okay, if you end up applying for Medicaid and Medicaid starts paying for you, the first thing they do is put a lien on your house. And so a lot of those social workers that work for the state that help you get on Medicaid will tell you to go get a reverse mortgage before you apply for Medicaid. Okay, because you're protecting some of that equity. And so it sounds strange, but there are very logical reasons why these types of products or investments can be useful to protect some of that money and that equity. All right. Have up-to-date documentation. Now, I said, if anybody can argue that you're mentally incapacitated, you got to stop playing with your documentation. But at the same point, the more the power of attorneys are up to date, the more your heirs or whoever's in charge of you while you're incapacitated will be able to utilize them. We experience a lot of pushback on power of attorneys. It's very normal because unfortunately plenty of fraud can happen out there. And so reasonably, all of these entities that need to listen to you, whether it's financial or God forbid you got to do real estate transaction with power of attorneys. I had to do several. They're painful because nobody wants to believe you. I had doctor's letters with saying they're all, she's got Alzheimer's, everything, but they still push back. So understand, the more up to date these documents are, the better off we all are when we need to use them. Name a personal representative, and please don't hide your documentation in a safe where nobody can get at it. Somebody's got to know where your money is. Somebody's got to know who to contact. And being in this business, it's important for our clients to know that, hey, tell your heirs just to call us. We know where everything is and how it all works, and we can just kind of guide them and help them through this process. That's really easy. So they have a one-stop shop to go to. So it's important to understand that there's got to be somebody that jumps to action when you pass away. Okay. And it's nice to have somebody to hold their hand and help them through this, because they should be distraught. Hopefully they're distraught that you had passed away. But somebody's got to jump in and get all the death certificates, get them to all the accounts, get the beneficiaries their money, and get things cleaned up. And so naming that personal representative is important. Let's see, question came in. Will fixed indexed annuities protect your assets like life insurance? Yes, annuities, yes. Life insurance and annuities are creditor and lawsuit protected. Okay, so to get the documentation, these will-based plans, the first problem we have is if you go to an attorney for a will-based plan, a lot of them, not all of them, a lot of them will try to talk you into a trust. Okay. They will overcomplicate your situation very quickly and make you realize you have to have a trust. Okay. The other side of that is there's plenty of honest attorneys out there. 99% of them give the 1% a bad name. Sorry if there's any attorneys on this call. I'm just making fun. Okay. So there are great websites out there if you want to avoid dealing with an attorney. If you have a very simple situation, we never have a problem with that, especially if you have an advisor that is there to kind of help and guide. Good advisors that treat their clients the way they should be treated should certainly be able to help out in this process and kind of guide you through it. They can't create legal forms themselves, but they can tell you what you need and where to get it and all that stuff. We've often used LegalZoom.com and US Legal Forms. The State Attorney General's website has a lot of the documentation as well. So there's lots of places that you can get documentation for free, if not for small amounts of money, as compared to going to an attorney that, will-based plans, we're seeing about $500 to $800 is the going cost for a will-based plan. But they quickly turn into thousands of dollars because they talk you into so much more. So just be careful about that world, and with a good advisor, these websites can usually handle most situations. All right, so that's a will-based plan. Now let's talk about a trust-based plan. This is important because we have to understand that all we're doing is the exact same thing, except we're putting a middleman in. We're creating a company that owns all of our assets. Okay, we are literally creating, like Carl said there, an LLC. We're creating a business, and we're saying, business, you own everything in my life, but I'm naming myself in charge. That's what a trust is. Okay, a trust is a document that says, I'm an entity, I own everything, and this person's in charge of me. And if this person isn't in charge of me, that person is. And if that person is, here's everything they're supposed to do. It's an all-encompassing document that creates this entity that takes care of all of your stuff. And if you're not able to, then they say who is. So let's go back to this priority totem pole here. What's important in a trust-based plan? Guess what? Proper titling is still first. Anything that can be owned by the trust should be owned by the trust because it avoids probate if an owner is still alive. Think about that. A trust can't die. There's no birth date or death date on a trust. It's not a living human being. The company lives on after you. Okay, so if a trust can't die and it owns your house and it owns your bank account and it owns your money and it owns your car, then nobody dies. Even though you passed away, the trust didn't die. So the trust already owns all this stuff. So anything that can be owned by the trust, the only things that can't be owned by a trust are any IRAs, including 401ks, 403bs, all those, and any Roth accounts. Okay, and then stuff, the grandfather clock, the jewelry, things like that, collections of things. Okay, so that's the only things that cannot be titled into the trust. Everything should be owned by the trust if you have a trust. So when I say your trust is not properly funded, it's because you have not put everything in the trust. Then your backup, beneficiary designation, avoids probate if direct beneficiaries are properly listed. Well, if everything is owned by the trust and the beneficiary, I guess theoretically should be the trust, just in case there's any mix-ups. Little redundancy never hurts. If you can't make the trust the owner, you can make the trust the beneficiary. Theoretically, you could put on your IRAs and your Roth accounts the trust as the beneficiary. I will tell you, you typically don't want to do that, just to avoid an issue that arises occasionally. Because if this issue arises, it's disastrous. Okay. When trusts are written properly, okay, very distinct when they are written properly, and not all attorneys write them properly. Properly written trusts can accept IRA money and pass it to heirs without any taxation. But one tiny little screw up in that process or misunderstanding at your custodian, meaning Fidelity or Schwab or whoever holds your IRAs, any confusion, any question, any gray area, any problem at all, the custodian will tax every penny of your IRA. They'll take 40% of it, send it to the IRS and send your heirs after tax trust money. That's an enormous, enormous mistake. And to avoid that, we choose to bypass the trust whenever possible, only with your IRA money and Roth money. Okay, so at best abilities, we try to avoid the trust with your IRA and Roth because we want to avoid the possibility of that happening. If it's human beings, they split it up and send it right to them. The inheritor, your children or whoever your heirs are, will then open an inherited IRA account and deposit it in there, and there's no taxation. And now with the new rules, they have 10 years to get the money out of there. And they can spread out the taxation, and it's better for everybody. Okay, so everything that can be owned by the trust should be owned by the trust. Everything that can be beneficiary sent to the trust via the beneficiary should be sent to the trust, other than your IRA money, pre-tax, all of the pre-tax accounts, 401ks, 403bs, all that stuff. Typically, you should not send that to a trust either through titling or beneficiaries. You should send it directly to human beings. Okay. Now, third priority on the totem pole is trusts. If your beneficiary says it goes to your son, but your trust says split it 50-50, the beneficiary wins. Your trust is virtually meaningless. It's only there if you screw up and don't do this stuff properly. Okay. So now, once your kids get this big book and they have no idea what to do with it, unless they're attorneys and do this for a living, they have no idea what to do, and they start reading it and laugh, and they find the attorney's phone number that you left their card in there, and they call the attorney, and the clock starts ticking, and the attorney is charging. Okay, it doesn't have to be that hard. Okay, the trust owns everything. Okay, whoever you put in charge is got a list of instructions. Yes, it's written in a lot of legal terms and a lot of difficult words that people don't understand. And the attorneys do this on purpose because, well, one, they want to cover their own rear ends, and two, they want more work after you pass away. That's why these trusts are big, thick books. Okay, they intimidate your heirs, but they're really not that hard. So I'm a big fan of, in layman's terms, writing a letter to your heirs and to specifically who is in charge of this trust. Okay, I want them to have a simple letter that says, here's really what our wishes are. Here's really what this trust says. Sell everything and split it up equally, or whatever it is that you want done. Write it in layman's terms. Help them out. Okay, that's important. Summarize what you wanted this trust to say in layman's terms, and that will help your heirs tremendously get this cleaned up and taken care of. Okay, gifting again. Notice that the will-based plan was exactly the same, other than we switched the trust in for the will. That's it. Okay, so we've got proper titling, proper beneficiary designations, the trust, and then careful with your gifting. That's a trust-based plan. It's the same. If you mess up here, you're going to probate, period. And I can't tell you how many people I've met with trusts that if they did nothing after meeting with me, they would be in probate, or their heirs would be in probate. It happens so often that as we go through the documentation that you need in a trust-based plan, the trust, if you go through your book, includes a pour-over will or a last will and testament. Some of them actually call it a pour-over will. Some of it lists your last will and testament. And you think, oh, well, that's my will. I have both. Well, not really, because the will that is attached to a trust is really a will to go into court with when you're in probate. And that's the only purpose of it. And that will says everything I forgot to put in my trust belongs in my trust. The courts sign off on it and send you on your way and give you this letter that says, move that to the trust. And now Chase, Bank of America, whoever, wherever you need to tell them, oops, we need to move this to the trust. I know it's individually owned and had no beneficiaries, but here's the court signing off on the trust is the rightful heir. Okay. It happens so often that in every one of your trusts, there's a document ready for probate. That's what's going on here. Okay, so this is an additional document that you need and is a part of every trust. Then you need a trust. This says what happens while you're alive and well, meaning it says you're in charge. Okay, you can create a trust that says you're not in charge if you want to, but for the most of us, a living trust says we're in charge while we're alive and well. Then it says what happens if you become mentally incapacitated. It instructs the world as to who's in charge of you and what their duties are. Okay. And then what happens after you pass away, who's in charge and what they're supposed to do. Okay. And then the same medical power of attorneys, the same living will, the same power or financial power of attorney. These are the same as the will-based plan. Okay, so these plans are very similar, but they're very different. Okay, honestly, a trust really complicates things. So if you have a complicated situation, you probably need a trust. But if you don't have a complicated situation, you probably want to avoid a trust. It makes it more difficult on your heirs. Complex plans need an attorney with a knowledgeable advisor. And I say that because I every once in a while run into a situation where we meet somebody who has a second home in a state that doesn't allow a beneficiary deed. Well, it's really just a cabin. It's nothing special about it. It's not a difficult state. It's just a state that doesn't allow a beneficiary deed. Well, the only way you're going to stay out of probate in that state is by having a trust, and that trust needs to own that house. Well, if you want to jump onto LegalZoom and just create a trust just so you can take care of that house, that's fine. But the rest of you that actually have difficult situations, whether it's because you own LLCs or you have a special needs child, if you have a difficult situation, you need an attorney that will actually craft a trust that is very specific to you and your situation. Okay. There are a lot of different trusts out there. So we'll talk about a handful of trusts here and there, but the reality is the vast majority of us just need a living trust. But there are special needs trusts. There are spousal access trusts. Those are great ones to avoid estate taxes in some of these states. Okay. It's otherwise known as an AB trust, and I'll bring that up coming up here. Fund your trust. Okay. I think I've hit that a few times, how important it is. All your money accounts and bank accounts, all the money should either be owned by the trust or the beneficiary of the trust, except IRAs or Roth accounts. Automobiles, own them by the trust. Okay, I had an attorney tell my parents, don't worry, your kids can just forge the signature. Don't worry about putting it in the trust. There's this fear of a car owned by a trust. Somebody will seek out and cause an accident because they think if the car is owned by a trust, then they must be rich people. There are other ways to figure out whether you're rich or not. I'm sorry. If you're rich, you can be a target. It's just going to happen. Look at it this way. All those speed cameras, if you get caught in one of those speed cameras and it says the Miller Family Trust, well, they have no idea who you are or what the address is or who's the owner of that vehicle, and you can avoid some of those tickets. So there's pluses and minuses, but the reality is if you pass away and you've got a broken down vehicle in your driveway, Your heirs can't even donate it to a charity. What is it? Cars for Kids. One of our heirs called Cars for Kids and said, hey, you can come pick up this car anytime you want. And they required ownership documentation, which there's an obvious reason for this. Okay. You don't want to wake up and look in your driveway and your car's gone because somebody donated it to a charity and just said they owned it. Okay. So they had to go to probate just to donate a car that was worthless, broken down and worthless. So we have to be careful about these cars. No, and some people will argue not to put it in a trust. I'm of the opinion, throw it in a trust. Insurance policy, certainly in the trust. Make sure everything's in the trust except IRA or Roth money. And then carefully name your trustees. Okay. So anybody can overcomplicate a situation. The less complicated you make it, the less bickering and arguing goes on afterwards. So keep that in mind when you go through this process. An attorney up in Washington State tried to convince my parents that they needed to do what I call manage the money from the grave for my sister, who has raised 3 wonderful children, put them through college, ran for public office, owns her house free and clear, had a successful career. And for some reason, the attorney picked on one little thing because she wasn't as responsible with money as I am. And they wanted to create this super fancy trust that managed the money and doled it out a little bit at a time through the next several decades. That is overcomplicating it just so the attorney can make more money. Okay. And these attorneys can be very good at trying to find a reason to make it more complicated. So just be careful. You know, there's so many what ifs. Well, what if this happens? Well, what if this happens? How do we cover it if this happens? If my third uncle's cousin's daughter's niece gets a DNA test and I find out they're my child, but it's after I pass away. And I mean, there are only so many scenarios that you can cover. So be very careful about overcomplicating situations and name your trustees carefully and think through this. Start with an outline of your wishes. In a perfect world, this is how everything would happen, and you work on that. All right. So some of the larger estate issues going on out there are temporarily gone because we're over $11 million per person. That means if you're married, we're over $22 million. Okay. So we went to a situation where it was 2013 or something like that. We went to 5 million and it was permanent. Back in 2011, it was $1 million, but they argued about it every year and it was a negotiating thing. And they agreed upon it and they put it up there. It was arbitrary. It was not law. Well, now we have it as law. It is it's 5 million plus inflation every year. Okay. And then with the tax package that we got a few years ago, they doubled it temporarily. So now we're at 11 million. Okay. And they're increasing it to inflation. And then in 2025, it goes back down to 5.5 and they continue to adjust for inflation. Okay. So what this means is anything over $11 million each, the estate tax is 40%. Okay, so you can see how much this has changed from 2011. It was 55% and $1 million. Now it's only 40 and 11 million. It's a big difference. So everything over. So if you die with 12 million, then $1 million of it will get taxed at 40%. That's what you have to worry about. And if you're married and you die with 12 million, you have an exemption of 22 million because it is portable. Portable means if one spouse passes away, the surviving spouse can file a piece of paper with the IRS and get their exemption as well, effectively doubling the surviving spouse's gift, estate tax, and generation skipping tax exemption. So if there's no estate tax on 11 million or less per person, what is this annual gift exclusion for? This baffles a lot of people. Okay, so I'm going to make this really easy. I have a child. I am leaving her alone this weekend, and I am going to give her, and this is just a wild scenario, I'm going to give her $20 for dinner each night that I'm gone. Okay, so I give her $20 for one night, I give her $20 for another night. Should I have to alert the IRS that I just gifted my daughter $20? Do we all want to worry about that? Think about how many times you gave your kid money or food. I feed my daughter all the time. Do I need to file that with the IRS? And the answer is no. None of us remember having to do that because we don't have to do that. And so this $15,000 is really just that threshold. Okay. Every year you're allowed to give up to $15,000 to any individual and not report it to the IRS. But if you give more, then it's time to start reporting to the IRS and they will reduce your lifetime exemption. There's no taxation. My great aunt gave my mother, right when my great aunt went into long-term care, she gave my mother everything. She gave her $700,000. Just gifted it right over to her, wrote her a check, sent it to her. Here's all my money. Take care of me. Okay. We filed the form with the IRS. We reduced my great aunt's lifetime exemption by $700,000, but my mom didn't owe taxes. There were no estate taxes because this is a gift, estate, and generation skipping tax exemption. So there's no taxation. It's not income to my mother. Okay. So the 15,000 limit per year per person is simply so we don't have Big Brother requesting us to tell them everything we do every single day of the week. Oh, the forms we'd have to fill out. It'd just be nonstop having to keep in track of everything I give my daughter on a regular basis. I don't want to have to deal with that. And that's why we have this $15,000 exemption. So don't overcomplicate it. If you give $16,000, there's still no taxation owned. It's just technically you have to file the form. That's all. And it'll reduce your lifetime exemption. Is that really a big deal? Well, if you don't have $11 million, it's probably not a big deal. Okay. If you own real estate in any of these states, some of them don't really matter, but some of them really do. When it comes to state estate taxes, it's based on the primary residence. So if Minnesota can claim you as their primary residence, you and your entire estate are subject to their estate tax. Okay. If you just had a rental property or a cabin or a second home there, then they can only claim what's in their state when it comes to their estate tax. So this list is as updated as I can, and some of these states have some crazy weird inheritance taxes, and the verbiage in each of those states is completely different, so you have to be careful. So states you have to avoid if you have considerable net worth. Illinois only has a $4 million limit, meaning everything over 4 million, they're going to charge 16% on the estate tax. This is separate from the federal estate tax. Although the feds will deduct from what you owe them anything you paid to the state, if you had $10 million, you weren't subject to estate tax federally, but you were in Illinois for 6 million at 16%. That's a lot of money. Okay. So some of these states, you have to be really careful. Iowa and Kentucky, just get out. Don't own real estate in Iowa or Kentucky and pass away. Sell it before you pass away. Maine and Maryland are fine. All these first ones are fine because they say they match federal, which is really smart. All the states should be doing this. That means if you're subject to federal estate tax, they're going to take 16% or 12% of it and give the feds the rest. The feds want 40. and they're getting 16 and 12 of that 40 because the feds let you deduct what you pay the state. Maryland, get out. Get out of Maryland. They have the matching federal, which is no big deal, but then they have that weird inheritance tax. So be careful about that. Massachusetts, anything over $1 million, you're going to get taxed. Be careful, get out. There's Minnesota, 2.7. If you got more than that, get out. Crazy inheritance taxes in New Jersey and Nebraska, get out. New York's fine. Oregon's $1 million, get out, get out, get out. Pennsylvania, crazy inheritance tax, get out. And then you got a few lower ones, $1 million and $2 million in Rhode Island, Vermont, and Washington. Washington's got the big one here, 20%. And that's where my parents are. So fancy trusts and things like that have to be done. Okay. So state estate taxes exist. We just need to be careful of some of these states. Arizona does not have an estate tax. We're very retiree friendly. All right. So some of the fun stuff you can do out there. This is a bit of an eye opener for a lot of people. There's a lot of different types of trusts. If you are charitable and you plan on leaving whatever's left over to charities, there are fancy trusts, whether you're rich or not, that you can take advantage of the charity, the charitable nature of your giving now while you're alive versus waiting till after you pass away and don't get any benefit from it. So there are charitable remainder trusts. They give you some of the charitable benefits now while they still fund your retirement, knowing that the rest of it will go to charities later. Charitable lead trust. You want to see something really crazy when you're super rich and you're super smart, like say Bill Gates, the Clinton Foundation, Warren Buffett. They're all doing this. Okay. The essence of this, a charitable lead trust. You put money in a trust. I'm simplifying this, but you put money in a trust and you invest that money and you take some of the profits. Okay. I said this very specifically, some of the profits. So if there's an 8% profit this year, you only take 4% of that profit, not 4% of the money, just 4% of the profit. So just some of the profit. So if you're super rich, Warren Buffett gave, I think, half his net worth to Bill Gates Foundation. Okay. Wonderful foundation, does a lot of wonderful things. All this money is in this foundation, invested. They're taking some of the profits and doing wonderful things with it. Theoretically, whatever your beliefs are, I don't care. Charitable activities with some of the profits. Here's the thing, the way this tax code, way this all works is, in my example, $1 billion was put into the charity. 8% earned a year for simple math, 4% went to charitable activities while the rest of the money continued to grow. That's right, the billion was still growing because they were only taking some of the profits and giving it to the charitable activities. Okay. Once the part that you're giving to the charitable activities meets the dollars that you put in, so that 4% over 18 years achieved the $1 billion, then what's left goes to your heirs. Tax-free, estate tax-free, behind the scenes, nobody needs to know. So in this case, theoretically, Warren Buffett gives $1 billion to the charity. Over the next 18 years, they're going to peel off 4% of the profits, while the rest of the money's growing. 18 years later, there's about $2 billion in there that'll get dispersed to their heirs. Long after he's gone, most likely. But this is what the super uber rich can do. This is what charitable foundations can do. They have the ability to do these things. And I'm not saying this is a bad thing, but this is how super rich can get away with not paying estate taxes. They're saying, well, as long as you gave charitable activities $1 billion, who cares? That's really what they're saying. They did some good with their money. And then their heirs will never have to work a job ever again. All right. Fun little way to handle things. Here's the very useful one we see quite often in two scenarios. For instance, my parents live in Washington State, and there's $2 million exemption each, essentially. Okay. So when you do a spousal access trust or an AB trust, basically you each have your own trust. Okay. So just for round numbers, Washington State has a $2 million estate tax exemption per person, but it's not portable. If one passes away, the other one doesn't get double the estate tax. So let's say my dad passes away, they take $2 million, put it in his trust, and it sits up here, becomes irrevocable, but says that the surviving spouse can use it for this, and this. Okay. And it stays here until my mom passes away, and then her trust gobbles up the rest of it. And then it gets dispersed to the beneficiaries. Okay, so this is very useful to split an estate for estate tax purposes. But it's also very beneficial for second, third, fourth marriages, for people that have separate assets. So you have a married couple with separate kids, with separate beneficiaries, but maybe a house that they commonly own. And that's what's great about these spousal access AB trusts. You're essentially creating a separate trust for each spouse. When one passes away, it puts all that spouse's assets in this trust and says what the surviving spouse can do with those assets while that surviving spouse is alive. But when they're both passed, then they each have their separate trusts with their separate assets, and they go to their separate heirs. So we find it very useful when it comes to the marriages, late life marriages with separate families and separate assets. Very useful in those situations. Irrevocable life insurance trusts. We run into people quite often that own farms in the Midwest that can be worth lots and lots and lots of money. You may wake up and realize you're a multimillionaire and you didn't even know it. If you have to worry about estate taxes and you want this farm to live on after you and you have heirs inheriting it, well, then possibly be given a big financial burden, whether it's because of state estate taxes or federal estate taxes. You may have to worry about them having to pay a huge bill for estate taxes just to keep the farm. And the only way they're going to do that is sell the farm to pay the estate taxes. So we got to be careful about that. And so that's what irrevocable life insurance trusts are for. You get a big life insurance policy that you are the insured, they are the heirs, but the owner is the life insurance entity, and it's irrevocable. So therefore it's out of your estate. It's not part of your estate. You're gifting money to pay the payment every year. And whether that's the farm proceeds paying for that or your own personal money, you're gifting it out of your estate. So your heirs will receive that money completely tax-free and estate tax-free as well. Gifting the $15,000, we don't have to just give cash. There's lots of ways we can handle this. Okay. So if you're pushing the limits, I know that there's, the rumors and clamoring that they're going to bring the estate tax down to 1.7 was the last rumor I saw. Look, we have to live with the facts as we know them. We can't live with the speculation of what this politician's going to do or that politician's going to do. We can't get caught up in that world. Okay. So be careful about worrying about those things. But if you're pushing the limits of the 5 million mark, which is truly where it is, then we do need to look at the strategic gifting that you can do out there. And there's lots of fun stuff that you can do. One, medical and education expenses, as long as you pay them directly to the institutions, there's no limit. If your daughter has a $20,000 medical bill and you want to pay it, as long as you pay it to the hospital or whatever medical institution, you don't have to worry about the $15,000 limit. Same thing for education expenses. Don't hand it to them, hand it to the institution. Gifting 529s, you can do 5 years worth all at once if you want to. So if you're trying to move money out of your estate all at once and you have 10 great grandchildren and you want to put a bunch of money in each of them, you can do that. Okay. So create documents now if you haven't. So this is really trying to put the importance on that. If you haven't done anything, I'm not telling you to change what you have. I'm telling you that if you don't have anything, please hurry up and go do it. You've got to get this stuff in place because something may happen. I mean, COVID has been a big lesson for a lot of people, unfortunately. List your beneficiaries properly. You should put a lot of time and thought into that, making sure every account has beneficiaries, whether you're going with a will-based plan or a trust-based plan. It's important. Will-based plans are best for most. Okay, so most situations, the average person out there, all you need is a will-based plan. Save money, use the internet, have a knowledgeable financial advisor, meaning, look, you don't have to go to an attorney to get a lot of this stuff done. It's pretty basic, and we have lots of great websites out there to get stuff like this. And there's lots of entities at the state of Arizona level that'll give you some of the documentation for free. If you get a trust, please put some effort into funding the trust. There are a lot of attorneys that'll just hand the trust to you and do nothing, which means your house is still in your name because nobody filed the deed, which means, there's so many problems that the attorney cannot go to your bank and say, change the ownership to a trust. The bank will not take a letter from your attorney and do things like that. You have to go in and sign documentation and change these things. Okay. So it can't be left up to other people to do. Utilize a trust for the following common reasons: large estates over the federal exemption limits, real estate in multiple states, family businesses, difficult family dynamics. There's more difficult situations get, the more we start moving to a trust. It can handle a lot of different things. So be honest about your situation. Understand that retirement planning is not just investing your money. You've got to think about all well-rounded sides of this and making sure that that things are taken care of after you pass away. So be honest about your situation, set goals, educate yourself, develop a strategy, inspect what you expect, and consult with knowledgeable, unbiased advisors. Let us know if we can help out. If you want a copy of the presentation, you can simply shoot us a quick email and just say, hey, can you send us a copy of the presentation? Give us a call. Let us know that you want a copy. We'll send it over to you. We have plenty of free reports out there. Some of them are on our website. Some of them we just offer up here. We've got one on estate planning strategies and things like that. I think this one talks a lot about that letter you can write in layman's terms. Letter of instruction is kind of the term that a lot of people use. But free reports, just let us know. We'll send them to you. And then certainly if you want to meet with me for any reason, in situations like this, again, we're not attorneys, but we are much more capable of looking at the big picture and making sure that you're getting what you need as opposed to what somebody makes you think you need. And that really is important because a lot of people overdo this. And looking at the big picture and being realistic about your situation is the first place that you start. The nonprofit requires I give at least an hour of my time. I don't charge for appointments. I'm more than happy to meet with you, whether it's in person or even over Zoom. More than happy to help out where I can and refer you to anybody if I need to. And then our nonprofit website, fpfeaz.org, is a great place with lots of resources. You can follow where all of our upcoming classes are and all that stuff. Our live Q&A essential on estate planning is April 12th. You're able to get that on there. But there's lots of free resources on here. We've got all of our mini classes on here as well. Lots of different topics that we work on with that. So jump on that website and keep an eye on where our classes are. Hopefully we'll go back in person at some point soon. But I think we're going to keep the element of Zoom out there as well, doing the Q&As, and combine that with the in-person classes as well. Okay, I see there's a question. I'm going to pause or stop the recording and then open it up for questions.